Good morning, class. I know I introduced myself on Canvas, but I'd like to formally introduce myself here. I'm Dr. Davis, and I will be your professor for the remaining of the semester. What I'd like to do today is discuss Chapter 6, so this will be your Chapter 6 lesson. I have also uploaded a PDF of this PowerPoint for those who also like to go back and be able to read through and take better notes. So let's jump right into it. In Chapter 6, we're going to discuss juvenile court processing, status offenders. We'll talk about what crossover youth are, and we'll also get into some Supreme Court decisions. So the learning objectives for this lesson are that by the end, you will be able to summarize the development and legal norms of the juvenile court, to describe the social control of status offenders, explain the structure of juvenile court, as well as who the key players are, describe pretrial processes, procedures, and decisions that an intake officer will make, explain what plea bargaining is, summarize the adjudicatory process, describe what a disposition hearing is and what disposition alternatives are available, as well as describe the various sentencing alternatives for juveniles. So what is the purpose of juvenile court? Well, the juvenile court, we know, was developed so that we had a separate court from the adult system. The idea was that it wouldn't be for punishing youth, but the salvation of children. So we wanted to rehabilitate youth. And trust me, you will be sick of the word rehabilitation by the end of your juvenile justice class, because that is what our entire system is all about. So we wanted to have an informal court processing because adult court was so formalized. There was this idea of parens patriae that we still go with today, where judges and the court system look to act as the parent of the offender and the guardian. So they're going to take on that type of a role rather than, speaking to the child in such a stern manner. They're going to talk to them like a parent would. So constitutionalists have argued, however, that because of all of these things, juveniles were being denied procedural rights. So they argued for 1, the adoption of separate procedures for handling dependent and neglected youth, the use of informal adjustments more frequently, so that we would avoid official court action being taken on youth, as well as procedural safeguards for youth during the adjudication hearings, which is the first hearing a juvenile is going to have in juvenile court. So let's look at some important Supreme Court decisions that affected how juvenile court works. So in 1966, in Kent v. United States, the Supreme Court said that juveniles have the right to a hearing if their case is going to be transferred to the adult court system for sentencing. We're not going to get too much into transfer hearings here because we're going to discuss that in Chapter 7. Then in 1967, we have Henry Galt, where they said juveniles do have the right to certain due process. So they have the right to receive notice of the charges that are being brought against them. They have a right to be represented by counsel, to confront and cross-examine witnesses, as well as to avoid self-incrimination. And then in 1970, in Winship, they said that, juveniles are also entitled to proof beyond a reasonable doubt. The prior proof was a preponderance of the evidence, which is about a 50% certainty that the juvenile committed the act. Beyond a reasonable doubt raises it to the same standard in adult court, which we say is roughly more than 75%. So it's more likely than not that this juvenile committed the act. So a judge has to make that determination. And then in 1971, the Supreme Court did say that juveniles do not have the right to a jury trial. So it's important to know they don't have the right to one, but some states do allow for juveniles to have jury trials. And then Breed v. Jones in 1975 said that when you do transfer youth to the adult system, if you hold an adjudication hearing in juvenile court and then transfer the case to adult court and have a separate trial, that does constitute double jeopardy, which we know is unconstitutional. So what are status offenders and how do they fit into juvenile court? We know all about juvenile delinquents. So status offenders are those who commit acts against statutes that apply exclusively to juvenile behavior. So these are offenses that an adult could not be charged for. They're things such as truancy, underage drinking, running away from home. Obviously, adults are not going to be charged with those. And then we have these general statutes for ungovernable or incorrigible behavior, we call it. This is where, say, a parent is just not able to control the behavior of the child in the home. They have frequent curfew violations. The parent may not know where the youth is oftentimes. The youth doesn't follow the rules of the home, and the youth is just generally defiant in the home. They could even be verbally abusive or aggressive towards the parents. If it's physically aggressive, it's typically going to end up turning into criminal charges, but it could be minor physical outbursts of the child as well. So in 1974, the Juvenile Justice and Delinquency Prevention Act said, you know what, we need to deinstitutionalize these status offenders. So prior to this, these types of offenders were being housed in secure detention and institutions with juvenile delinquents. So this act said we need to take those status offenders out of these institutions and keep them separate from juvenile delinquents, because we found that placement in secure detention and correctional institutions could be damaging to status offenders. So status offenders are really better served through social services, mental health, and community agencies. It is important to know, though, that most status offenders are still served through our courts in the majority of the states in the United States. So what do the critics say? So they say that juvenile court should not have jurisdiction over status offenders for these reasons. Status offender statutes are unconstitutionally vague, that even though status offenders don't commit delinquent acts, they're oftentimes confined with delinquent offenders, and there's this idea of an iatrogenic effect. It's a big word to simply say that when you put low-risk youth with high-risk youth, the low-risk youth are going to end up taking the behaviors of the high-risk youth and becoming more delinquent. It doesn't work backwards, unfortunately. They also said that processing and confining status offenders promotes unlawful behavior because you're treating them like a delinquent, and that these are a special class of youth that just inherently need to be treated differently than delinquents. So in Maine, New York, and Washington, they actually did decriminalize status offenses, which means they removed them from the juvenile court jurisdiction. However, there was then subsequent legislation in both Maine and Washington that partly repealed these to give jurisdiction over specifically abandoned, runaway, or seriously endangered children, because they realized that those social services agencies and the community agencies couldn't serve the best needs of these youth, and that they really were best served in juvenile court. All right, so now let's get into what are crossover youth. So a crossover youth has also been called, we call it a shared case in our county, or a dual jurisdiction case, just dual jurisdiction, duly adjudicated youth, or cross-system cases. So these are youth who are involved with both the child welfare system as well as the juvenile justice system. So they're exhibiting both types of behaviors, dependent and delinquent behaviors. Unfortunately, there's a huge lack of integration and coordination between the two systems, and I can attest to that, having been a probation officer. The child welfare system, we call it OCY, the Office of Children and Youth. They're often called many different names, but it all means the same thing. They will often close a case once a juvenile becomes involved with the juvenile justice system. They say that, well, you have the same types of services, and you can mandate that that youth participate with the programs and the services better than we can. So why don't you go ahead and just keep the case open? There's no reason for us both to be involved. They just like to get out as quick as they can. So then in 1997, we have this Adoption and Safe Families Act, which said that we have to have goals of permanence for youth who are in foster care. We want to look at protecting their well-being and also their safety. So there was an emphasis on achieving permanence for children. Unfortunately, there is a disproportionate number of minority youth in the child welfare system. It's not because these youth are more often neglected or abused by their parents. They're just more often placed in foster care. They receive fewer services. They have longer stays in the system, and they're less often reunited with their families when compared to Caucasian youth. So what does the juvenile court structure look like, and who are the key players within it? So we have, in juvenile court, it can be set up as either a separate state court It can be part of a circuit, a district, a county, a superior, a common pleas, probate, or a municipal court. So it's set up all different across the United States. In Pennsylvania, where I'm at, we have county courts. So some courts also have a juvenile judge who specifically sits over juvenile court. So that judge will handle the delinquency hearings as well as the child welfare or dependency hearings. So they handle both matters. That's the way it's set up in my court. Not sure what it looks like out in Nebraska. Then we have the key players. So we have obviously the judge, who's going to be your final decision maker on any legal matters before the court. Some courts will also have, they're called either a referee, a hearing master, or a hearing officer, and they're going to be able to handle just certain court matters. And the idea is just to take some of the load off of the judges. So you're also going to have a defense attorney present. So they're not only representing the juvenile, but they're advocating for the youth. They might even be acting as a surrogate parent or guardian to the juvenile while they're in court. Then you have the prosecutor, whose sole mission is to protect society. However, they also have the goal of ensuring that juveniles are afforded their constitutional rights. So making sure that we don't violate their rights as a state or as a county. And then you have your probation officer. So they're going to act as not only intake officers, which we'll discuss, they're going to assess the needs of the youth, they'll write reports for the court, and they'll supervise youth. So probation officers oftentimes are expected to go to court and present the case of how the youth has been doing, either while they're on probation, or present the case at a disposition hearing, which we'll also talk about, and give a recommendation to the courts. So, pretrial. Here's our first step in the juvenile court process. We start with pretrial. This consists of a detention hearing, the intake process, and it can include transfer procedures. So, a detention hearing must be held typically within 48 to 72 hours of a youth being detained in a detention facility. So, probation officers, we'll call them duty officers in this capacity, will take calls 24/7 because there's a 6-hour rule. At least in Pennsylvania, we have a 6-hour rule where it says that once an officer charges a youth with a crime, once they arrest them, they have 6 hours to either release that youth home to their parents or to detain them in a facility. The thing here is that that officer has to write up their entire police report, which we call written allegations in juvenile court, just explaining what happened, and they need to know what charges they're charging the youth with before we can detain them. That written allegation is their ticket into the youth center because we need to have probable cause to be detaining the youth. So the purpose of a detention hearing and the purpose of detaining a youth is, one, to protect the juvenile's safety, but also to protect society and to ensure that that juvenile is going to appear for their next court hearing. So some states will offer bail. There's 9 states that do. Some prohibit bail from being offered, which one of ours, we don't offer bail to youth. You're either detained or we decide that you're not a risk to yourself or the community and that you will return for your next hearing. So it's safe to just release you. If you want to equate it to release on your own recognizance, ROR, it's pretty much how it works. We might put them on a GPS. And some states just offer it as an option. There are negative effects to detaining a youth in detention. It not only exacerbates mental health issues, but it has a negative impact on their education as well as their employment. So education, they're going to be stopping the point of where they're at their home school and just picking up wherever the detention facility is currently at in their educational process. They're not going to be able to go out to work, so they may lose their job. It also leads to increased recidivism because it interrupts the natural desistance from crime process that youth will typically go through as they age out of crime. So our next step then is going to be the intake process. So an intake officer is a probation officer, and they determine whether the juvenile's case is going to be handled informally, whether it's going to be diverted from court, so offer things like a consent decree where the juvenile isn't adjudicated delinquent, but is rather placed under supervision in hopes that they can complete that without having an adjudication. They can also dismiss cases at the intake level, or they'll petition that case to court. So there are arguments that there's broad discretionary power given to intake officers. However, most counties have a checks and balances system within their department. So by this I mean, when the intake officer recommends that a youth is placed on an informal adjustment, or if they recommend that the case is petitioned to court, any recommendation they make, that has to be approved by their supervisor. It then has to be approved oftentimes by our deputy chief. And then if they're petitioning the case to court, or if they're petitioning for an informal adjustment, it needs to be approved by the district attorney's office. So there's a number of checks and balances. It's more or less that that intake officer is making the initial determination and making a recommendation to someone higher up then. So it's being checked. It's not like they're just making this decision and they're acting as a judge. So then we have lastly here transfer procedures. So at the pretrial stage, this is where certain felony offenses are actually eligible to be transferred to the adult court system for processing. Again, we'll discuss that in Chapter 7. So what is plea bargaining? Because this can happen typically before an adjudication hearing is when they're going to make this determination. So plea bargain is a deal between the prosecutor and defense attorney. The judge does have to agree to a plea bargain, however. I will tell you, I have had in court, I've seen cases where both the attorneys thought they had a great deal made up, brought it into court, and the judge looked at them both and said, "Did you really think I was going to sign off on this? Absolutely not. This is what I'm offering." So it's the defense attorney. So your client can either go to trial or accept this. It doesn't happen often. Typically the judge is going to accept the plea bargains. But here's the issue, that juveniles they're going to agree to admit to a lesser offense to receive a lighter sentence. One, it does reduce court costs and court load because we're not having to pay all of these key players to be present for long drawn out periods of time. But critics argue that innocent youth may be pleading to avoid harsh sentences, so even though they didn't commit the crime, they don't want to take their chances in court, so they're going to admit. Or you have violent and dangerous youth that are pleading to negotiate lighter community sentences. So regarding the innocent youth, I actually had a juvenile on probation. He ended up getting rearrested for 2 separate felony robbery cases. One was with a gun, the other one was not. They did transfer his case to the adult system. However, they offered him to come back to the juvenile system if he would just plead to both cases. So he sat down with me and I said, "Do not talk to me about either of these cases because as a probation officer, I can't speak with you about any case that has not been adjudicated that's with our system at the moment. You still haven't admitted to any charges." But children don't listen to what you tell them. And he said, his response was, "Well, I know I didn't do that one." I'm like, "Really? Really, man? So you're telling me you did the one? Don't say anything else. Please shut your mouth." But again, he's like, "What do you think I should do? Should I take the deal? I don't want to take my chances in adult court." And all I could tell him was, be honest. That's all I can tell you is you have to make the decision that you need to make. But at the end of the day, I'm just telling you that I would just be honest. If you didn't do it, then don't say you did it. But in his case, he did end up admitting to both of them so that he could come back down to the juvenile court system. Whether he did them both, I don't know. I do believe him that he did the one because of the way he uttered that expression. It was just so, off the shoulder that he mentioned, "Oh, well, I didn't do that one." But then you also have these, so you can have violent and dangerous youth that are pleading to those lighter sentences just so that they don't go to placement and that they can be put back out in the community. So we have to ask, are plea bargains fair? And do they actually protect community safety? So our next step then is an adjudicatory hearing. This is the equivalent to trial in adult court. In this case, a judge is going to review the petition and written allegation. They're going to hear testimony, and they're going to decide whether or not the youth committed the delinquent acts that are alleged against them. If a youth is adjudicated, this means that there is a finding, the judge had a finding, that the youth is a delinquent and is in need of treatment, supervision, and rehabilitation. Most proceedings in juvenile court are closed to the public and cases are kept confidential. However, some states do allow open hearings for certain types of offenses. Usually this is going to be your serious violent felonies or for youth who are above a certain age, say 17 or above, or 16 and above. They'll allow the public to come into the court hearings. We also are going to appoint counsel for youth if they're deemed indigent. So if they can't afford an attorney, we'll appoint a public defender for them. Or in cases where there's co-defendants, the public defender's office cannot represent both co-defendants or multiple co-defendants. So we just appoint private counsel who work for the courts on a case-by-case basis. So we're also going to review legal rights with youth at these hearings through things like an admission colloquy, which I did upload for you into the Canvas this week 6 module. So take a look at that. Counsel is going to go over that with the youth, and then the judge also, as they're accepting the admission from a youth, they're going to go down a few of those questions just to make sure that the juvenile does understand all of the rights that they have at that hearing. Our next step then is disposition. So this is the equivalent to sentencing in the adult system. There's 2 avenues by which this can happen. The first is it can be held at the same time as an adjudication hearing. So the order is going to read an adjudication/disposition hearing. These are typically going to happen when you have those plea bargains. Everything's going to be agreed upon in a nice, neat little package for the judge. You can also have a bifurcated system, and this is where you hold a separate hearing for disposition. Usually it's going to be within 20 days of an adjudication hearing, 20 to 30 days. There's certain rules in certain states for how long or how soon it has to occur after an adjudication hearing. But the pro to having a bifurcated system is that it prevents the judge from having prejudicial information when they're making the determination of guilt or innocence on that youth. Because at these separate disposition hearings, this allows a judge to have additional information on the youth so they can make individualized decisions. They're going to be given information such as predisposition reports or court summaries from probation. They'll have psychological, psychiatric, or drug and alcohol evaluations that are typically ordered at an adjudication hearing. They can't be ordered until a youth has either admitted to charges or has been found guilty of those charges. The judge will have access to victim impact statements, any prior police contacts that youth has. They're also going to look at the family environment and the family relationships and dynamics that are present with that youth, as well as their school records. So what are some disposition alternatives that are available to the courts? Well, the courts can dismiss cases, they can order restitution, place the youth on probation. Some youth are placed in foster home placements. A lot of those are going to be your crossover youth, where they're maybe more dependent than delinquent, but they still have some delinquencies. We're going to put them in foster homes because they're less secure. We have secure confinements. We have community-based residential programs. Sometimes youth will go to school in the community and then they'll stay at the residential program for the rest of the time. We also have state facilities as well as adult facilities for youthful offenders. So there's many options available. So what are some sentencing alternatives? So the juvenile system historically had indeterminate type sentencing, just like the adult court system. So this was where the judges had broad discretion and it was an arbitrary decision-making process. So most times youth are not going to be given a set time to serve on probation. It's just rough estimates. So certain placements will say, typically our youth aren't going to serve, they have to serve a minimum of 6 months on probation. If they complete everything, typically they'll be released. But if their behavior isn't up to par, if they're violating their probation, it can extend out up until their 21st birthday. In most states, juvenile courts can hold jurisdiction up until juvenile is 21. So we've in recent years, in juvenile court, have switched to a determinate sentencing type, which is just a more structured system that has narrow ranges for sentencing terms so that a youth knows what to expect. We also have blended sentencing used in certain states, where a juvenile is given both a juvenile and an adult sentence concurrently. Again, we're going to discuss that in Chapter 7 when we talk about transfer. Some states, however, do have mandatory sentences for either violent or repeat offenders, and this idea of graduated sanctions is used. So we don't want to say, take a youth and initially place them right into a secure confinement placement facility. We're going to give them the option to make it through probation first. If they violate, then maybe we'll put them on a GPS monitor to closely monitor them. If they continue with their delinquent behavior, then maybe we'll place them in one of those community-based residential programs. So you want to match the youth's behavior and just slowly step up the sanctions so that you're not tapping them out of the system the very first time they step in. With all of that said, what can we do to prevent delinquency? So how can we prevent youth from even coming into the system? Well, research says that the most effective interventions address ecological factors and parenting skills. That's parenting skills of the juvenile's parents. So multisystemic therapy is oftentimes used in juvenile court as a condition that will place youth on to complete. It's a family-based intervention that focuses on how the parent or guardian influences the juvenile's behavior. So we recognize that it's not always just the youth acting out. There's a reason, and what are the parents doing, and what is their role or responsibility in that? Then there's diversion programs like family group decision making, also called family group counseling, where there'll be a moderator. The family comes together with the juvenile, and sometimes you'll have outside players who are people such as aunts, uncles, maybe very close friends of the family who have a relationship with the youth and who see the youth often. They'll come together and come up with a plan on how they're going to address the youth's behavior and what the parents are going to do and what their role is. So it's a way to address things such as, here we see, we'll do family involvement in the court process, which actually improves youth outcomes. So we're going to have family involved in the drug courts. When juveniles are placed in mental health courts, oftentimes the parents are given things that they need to do to ensure the youth is being successful. Also, the parents may be required to enroll in parenting classes, or they'll be enrolled in skill building courses. So again, this is going back to that original idea of when the juvenile court was created, that it's not necessarily just a failing on the juvenile, but the parent does play some role in this. So in sum, we covered that juveniles do have certain due process rights, of which there are 4 that we covered. Status offenders can be served in juvenile court or through social services, mental health, and community agencies. Crossover youth are involved in both the juvenile justice system as well as the child welfare system. Juvenile court is more formalized now than it was at its inception. Pretrial consists of 3 parts. You have detention, the intake process, and transfer procedures. Plea bargains have been criticized for their lack of perceived fairness. An adjudication hearing is going to be equal to trial in adult court, where disposition is equal to sentencing in adult court. There are a number of disposition alternatives available to a juvenile court, and determinate sentencing and blended sentencing are now being used more frequently with juveniles in juvenile court. So again, this was your Chapter 6 lecture.